My name is Cliff Shirley. I'm the Chief Magistrate Judge here in the United States District Court. Today is February the 4th, 2016, and it's my pleasure and honor to be interviewing Richard Stair, former bankruptcy judge here in the Eastern District and one of the finest judges and men that I've ever known and had the pleasure to work with. We're doing this on behalf of the Knoxville Bar Association Legal History Video Project. So with that in mind, I will turn and begin the interview with you, Richard.
All right, Richard, why don't you start by telling us your full name and your date of birth?
I'm Richard Stair Jr., Richard Stephen Stair. I went by Richard Stair Jr. to differentiate myself from my dad, who was an attorney practicing here in Knoxville. I was born on March 30, 1941, here in Knoxville.
All right, so let's just begin at the beginnings. Tell us a little bit about where you were born and where you were raised.
I was born here in Knoxville, and as they say in East Tennessee, I was born and bred here. I went to school at Sequoia Elementary School, Tyson Junior High School. Back then we didn't have the middle schools. And I went to West High School.
What was your family unit like?
Well, my dad, Richard Stair Sr., was an attorney. My mom, Millicent Stair, was a homemaker. She raised 4 kids. I have 3 younger siblings. 2 of them have passed on. I have 1 living sister now, and we just were raised in a normal life here in Knoxville, and my parents were good to us, and we all got an education. And
so you were the firstborn?
I was the firstborn. I was the oldest of the 4,
All right.
and I took advantage of that.
And when you finished your high school, did you go off to college?
No, I went to the University of Tennessee, both undergraduate and my law degree. At the time I was in school, one could go to law school after 3 years of undergraduate. Can't do that anymore, which is what I did, and applied the first 40 hours of law school towards your undergraduate degree.
So
I did that.
You could get an undergraduate and a law degree in 6 years instead of 7.
That is correct. You can't do that anymore. Now, the price you paid for that was you did not get a JD degree. I got an LLB, a Bachelor of Laws degree. Shortly after I graduated from law school in 1965, I believe they went to the 3-year program. You had to get your undergraduate degree before you went to law school, and they gave out JD degrees.
Now, before we get into your law career and some other things, somewhere along this line, I know you got married.
I did indeed. I met Mary Wynn from Clarksville, Tennessee. She was a student here at the university. We married June 5th, 1964 in Clarksville, and we'll soon have, in June, have 52 years.
And real quickly, your family unit, did you all have kids?
We did. Our son, Stephen, our oldest son, was born in St. Louis when I was in the Army. Our second son, John, was born when we returned, and we have twin boys, Richard and Russell, who were born here in Knoxville in 1975. We're blessed with 3 wonderful daughters-in-law and 7 7 great grandchildren. Very precious grandchildren.
Grandchildren that are great.
Grandchildren that are great. Thank you.
You mentioned your military service. So when you finished law school, did you immediately go into practice, or did you have to do military service?
Well, when I got my undergraduate degree, I was also commissioned in the Army. I had been in ROTC, so I was commissioned a 2nd lieutenant, and had orders upon graduation from law school to the Army Artillery School in Fort Sill, Oklahoma. I had been accepted to the Judge Advocate General's Corps, conditioned upon passing the bar examination.
That's the JAG Corps?
That's the JAG Corps.
Okay.
There were a couple of us. We took the bar exam in July, I believe it was, and they had to pull our exams out early and grade them to see if we passed so we could get in the Corps. And I did pass, fortunately, and got in the in the JAG Corps. We
So
were...
the artillery never got the benefit of Richard Stair?
No, they never got the benefit. Artillery was at Fort Sill, Oklahoma, and Vietnam was at its zenith at that particular time, and that was a direct route in artillery to Vietnam. Our orders were changed, and I was assigned to the United States Army Aviation Materiel Command in St. Louis, and then ended up there. First, we spent 3 months, the latter part of '65, in Charlottesville, Virginia, at the JAG school, and then the rest of my military career was spent in St. Louis.
And in what areas did you primarily practice for the JAG Corps?
The Army Aviation Materiel Command did all the aviation procurement for Vietnam. I was in the JAG office and was responsible for overhaul and maintenance, contracting work. I didn't do any courts martials or anything like that, but for aviation procurement.
So a more transactional type practice?
Yes, well put.
So when you finished, when were you discharged?
1968, I returned to Knoxville in late September of 1968.
And did you begin a practice here then?
I did. My dad, as I've alluded to, was a longtime practitioner here in Knoxville. He had offices in the Hamilton Bank building. I was able to join forces with him. I had an independent practice, but he allowed me to come up there and share space with him and kind of nursed me through those early years.
Was that Stair and Stair?
Well, it was, but it wasn't, because we were independent in our practice. I paid him overhead as soon as I started making a little bit of money, and we had entirely different type of practices. But it was a blessing for me to have the opportunity to spend 18 years with him, because he was a very well-respected attorney here in Knoxville, and there were some other attorneys that he allowed us share space with him that I got to know well, and that were premier lawyers.
Who were some of those?
Well, Bob Ritchie. Bob, we had kind of a common story. Bob was coming out of the Army as I was going into the Army, and he approached my dad about renting space, and Bob set up an office up there. He later employed James A.H. Bell to work with him. Joe Tipton, who became a criminal court of appeals judge, worked there for a while. There were several others, but it was a good mix.
Was that the precursor then to the Ritchie, Tipton, and Bell
Oh,
firm
it
that
would have been. Yes, it certainly was.
Well,
Bob left after a while, set up his own firm, and when we ended up, it was just me and my dad.
All right, and in that practice, let me digress one second. How was it practicing with your dad?
Well, it was fine. I did not know how it was going to work when it started, but as I said, he had a different practice. He did primarily personal injury work. I got involved more in commercial type transactions, bankruptcy, and related matters. So we didn't have a conflict. It worked very well.
In addition to your work at that time, did you also have some other partial career in law?
I did. I worked part-time during the 70s for 6 or 7 years as an assistant district attorney general for Knox County. Ron Webster was the attorney general, and at that time, he was permitted to have part-time assistants.
So you could still have your practice, and then how often a week or a month?
Well, there were several part-time assistants, and I think we probably took terms on every third or fourth week. John O'Connor was down there at that particular time, Ralph Harwell, Herb Monsieur, and there were Don Coffey. There were several others, many of whom went on to defense work. So I don't know if the prosecution sent them towards the defendants or not. But
well, it's interesting that you're sharing space with some of the preeminent criminal defense lawyers, and then you would be in the prosecutor's office with a gentleman who would go on to be, again, premier criminal defense lawyer.
Well,
but you took a different track.
I did. I did a little bit of criminal defense work when I first started. They would appoint me. I needed to make a little bit of money, so I did. But then I went down one day. I'd heard about bankruptcy, didn't know much about it. Didn't know Clive Bear, who was the referee at the time. But I went down and talked to him, And at that particular time, the bankruptcy referee, I'm going to call him a judge because that's what he always was to me, and ended
That's
up
all I
being-
ever knew him was Judge Bear, and he would become one of the preeminent bankruptcy judges in the United States.
He very definitely was. At that particular time, the judge had as much an administrative function as he did a judicial function. And he appointed the bankruptcy trustee, so I went down one day and said, I need to do a little work, make a little money. Would you put me on the trustee panel? And he graciously consented to do that and appointed me, and that kind of got me started in the bankruptcy practice.
So, first let's talk just a little bit about Judge Bear, because at that time you said he was just a referee.
Well, I say just a referee. He was anything.
No, those of us that knew Judge Bear know he was never cotton to being called just anything.
Yeah.
But what was the appointment of a referee at that point?
Well, I'll give you a little bit of history. I'll be as quick about it as I can. But when I started practice in bankruptcy in the late 60s, early 70s, we were operating under the Bankruptcy Act of 1898.
1898.
1898, a very old act. And under that act, bankruptcy judges were arms of the district court. They were appointed as referees by the district judges, and it's my recollection it was a 6-year term. That changed later on, and I don't know if you want me to get into that at this particular
we'll
time.
get
or
into
not.
that, but were like the filings at that time, did they go straight to a bankruptcy court clerk, or were they through the district?
No, it was all, it went to the district court. All the filings for bankruptcy cases were in the office of the district court clerk. Then they were sent to the chambers of the bankruptcy judge. The bankruptcy judge held the creditors' meeting, presided over it, and then if there was any litigation, presided over that. There were some inherent conflicts in the system at that time.
I gather that you must have enjoyed that to some degree, the trustee work, and did that lead you to being involved in more bankruptcy in your practice, whether it was debtors or creditors?
It did. I kind of developed a niche. I enjoyed it. At that particular time, the Uniform Commercial Code was fairly new in Tennessee. And there was a learning curve for the banks and lending institutions in perfecting security interests. And one of the chief things we looked at as panel trustees was the perfection of a security interest. And often we found that there were some defects and were able to set aside these security agreements. That changed as that learning curve improved. But I enjoyed that. Made some mistakes along the way, and Judge Bear was never hesitant to point those out. But I started doing some debtor work, filing cases myself, doing some creditor work, representing some banks and individuals who had claims in bankruptcy cases, doing a little bit of litigation, and I found that I enjoyed it.
From my viewpoint, it looked like, as I look back on my time and career, that around the 70s, bankruptcy, though, and bankruptcy practice was sort of in its infancy, and it was about to take off. Is that a fair statement?
It is.
Particularly with the advent of the 78 code?
That's correct. The filings were fairly minuscule compared to what they became. I remember looking from time to time at the filings as I continued in office, and I think probably around the 70s and early 70s, there were maybe 2,000 cases filed across the district. That changed dramatically over the years. The evolution of the credit card, consumer credit came into vogue, and bankruptcy started to mushroom, and that old 1898 code was out of date.
And to put that in some kind of perspective, 2,000 filings back then a year, by the time you would reach your peak, it would be in the 20,000s, wouldn't it?
Well, we'll jump ahead. In 2005, the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005 came into effect on October 17, 2005. We'll perhaps talk about that a little more, but the lawyers weren't sure how to meet that. So there were 22,000 filings in the Eastern District of Tennessee during that year.
All right, well, let's back up. Let's we've gotten you kind of up into the 70s. You've gotten on the trustee panel. You've started a bankruptcy practice. Clyde Bear is still the referee. And then in 1978, the bankruptcy code changes. And I think, if I recall, there's some fairly monumental changes in
Well, let me back up just a little bit. In 1973, the Supreme Court, under its rulemaking powers, enacted a rule that even though the judges were referees, they would be called bankruptcy judges. So in 1973, Judge Bear became Judge Bear.
Okay.
In 1978, the President signed the Bankruptcy Reform Act of 1978, which totally revamped bankruptcy. It went into effect on October 1, 1979. Through that code, bankruptcy judges were created for all of the districts in the United States. They were created with 14-year terms, subject to appointment by the President and confirmation by Congress.
And in the great law of political unintended consequences, tell me about the jurisdictional problem between a bankruptcy judge and an Article III judge.
Well, the 1978 Act granted considerable judicial authority to bankruptcy judges. There was nothing that a bankruptcy judge could not handle. Sometime thereafter, a case entitled Northern Pipeline Construction Company versus Marathon Pipeline came through the system. It involved a bankruptcy debtor and a contract, and jurisdictional issues were raised. It made its way to the Supreme Court, and in 1982, the Supreme Court held that Congress had granted Article I bankruptcy judges impermissible Article III authority, and was unconstitutional. Now, interestingly, even though the judges were unconstitutional, the Supreme Court said, we'll give you a period of time to clean all this up. And I think they gave them 6 months or a year. They didn't do it. Gave them another 6 months or a year. And after about 18 months, Congress hadn't done it, so there was no bankruptcy court for a period of time.
Were you back to, how would you get your matters? Were you
Well,
being referred matters from the
They
district court
created
again?
a rule where district courts referred bankruptcy matters to bankruptcy judges, and ultimately that rule was incorporated into the Bankruptcy Judges and Reform Act of 1984.
So they finally got around to it a couple years later,
Finally got around to it.
codified some new rules.
They cleaned the mess up to some extent, but under the 1984 Act, bankruptcy judges were appointed by the Sixth Circuit. Merit selection panels were established, and the panels took applications and made recommendations to the
And that's the way it still is today.
That's the way it's handled today.
All right. And at the same time, around 1984, there was some pretty serious litigation here in the Eastern District involving some banks.
Well, the banks cannot file bankruptcy, but you are referring to what we term the butcher bankruptcy cases. After the World's Fair in 1982, at some point in time, 1984, there were United American Bank failed, City and County Bank failed, and there were a considerable number of spin-off bankruptcies. The major one was Southern Industrial Bankruptcy Corporation.
Explain that, because a lot of people, I think, probably think the butcher banks were all in bankruptcy. But in fact, banks aren't in bankruptcy.
No, bankruptcy code excludes banks, and banks are placed into receivership under the authority of the Federal Deposit Insurance Corporation.
So what was in bankruptcy court?
Well, there were a number of individuals who fell and fell very hard, and as I said, the most prominent institution was Southern Industrial Bankruptcy Corporation, which had the word banking in its name, and which misled many people. In fact, as I recollect, there was a sign in the lobby of SIBC that said not and in big print, FDIC insured institution. with the emphasis on the FDIC, which misled a number of people. After that failure, I believe the law was changed.
As I look back, my recollection is that was a pretty litigious time in bankruptcy.
It was a
court.
very litigious time. It was a very stressful time because so many individuals had lost so much money because every time one of the butcher banks would come up for an audit, SIBC was the cash cow, and they would raise money by raising interest rates, and interest rates got very high, but they would take that money and then they would cushion one of the banks to make it look good. Finally, they audited all the banks, and that was it.
What was the significance of that litigation and all that as it relates to your career?
Well, it started before I came on the bench. Judge Bear, it was very heavy litigation. There were so many lawsuits filed to recover money. In the bankruptcy code, there's a preference law where you can recover monies that have been paid within a period of time before the bankruptcy filing, and individuals were being sued, businesses were being sued. Some of the principals, both butchers were in bankruptcy. There were other principals, high-profile figures that were in bankruptcy. It was a very stressful, high litigation time.
And how did that wear on Judge Bear?
Well, I don't know. Judge Bear finally, his health was at issue, I believe, and he decided that it was time for him to retire, and he put in his notice that he was going to retire.
All right, so he's about to retire. Richard Stair sitting there as a practitioner in bankruptcy. How did you go from that to bankruptcy judge?
Well, when I learned of Judge Bear's retirement, I did a lot of praying and soul searching, and I really enjoyed what I was doing. I felt like I was qualified. I'd done a lot of it, both on the debtor and creditor side. I did not consider myself a particularly good trial lawyer. I could always see the other guy's side, or not always, but sometimes. And as a lawyer, you're not supposed to do that.
You were just kind of born fair.
Well, I don't know about that, but I talked to my dad about it. He wasn't much in favor. He never said I'm not in favor of it, but I could read his body language. I said, I'm going to do this. I need you to talk to me about it, and he did. And so I threw my hat in the ring.
Had you ever considered being a judge up till that time?
No, I really had not. But I do recall sitting in Judge Bear's court and ruling in my head on oral argument on some of the things that he was hearing. I suspect every lawyer does that.
So you said you threw your hat in the ring. What was the process then of throwing one's hat in the ring?
Well, there was an application process, and it's the same today as it was back then, as I understand it. A very comprehensive 25 or 30 page application form that goes back till the day you were born, and financial information, medical information, and then you send that in to the merit selection panel or to the circuit, and then the circuit appoints, the Judicial Council appoints a merit selection panel consisting of 5 or 6 citizens, some lawyers, some non-lawyers, and they interview the applicants and make their recommendation to the 6th Circuit.
So I guess you went through that process, and at the end of the day, they recommended you.
They did, and
then who appoints you, or who appointed you at that time?
I was appointed by the 6th Circuit. Even after all that, then you're subject to a background investigation that generally takes 90 to 120 days. But I was appointed by the United States Court of Appeals for the 6th Circuit.
And when would that have been, Richard?
I took office on October 1, 1986.
Okay. That process where the 6th Circuit now appoints, if I recall correctly in time, that was relatively new when you were appointed. Would you have been one of the earlier appointments of bankruptcy judges?
Yes, that process did not come into effect until the 1984 Reform Act, and I was appointed in the latter part of '86. There were only two bankruptcy judges here in the Eastern District at that particular time, and I'm sure there were probably a few appointments across the country, but certainly I was the first one here, and perhaps throughout Tennessee.
If we just paint with a broad brush first before we focus down, if my math's right, you practiced law around 18 years.
That's correct.
And how long were you bankruptcy judge?
28 years. I served two 14-year terms. I retired on September 30, 2014.
How did you find being a judge? You did it longer, but how did you find it versus being a lawyer?
Well, I enjoyed it. I didn't have to worry about the statutes of limitations and the billing hours and things that lawyers spend so much time.
Sometimes we sleep better at night than
Well,
lawyers, don't you think?
sometimes we do. I had the luxury of taking my time in deciding cases. I remember before I went on the bench talking with Judge Bear, and he advised me and said, "Now, there's only one piece of advice I'm going to give you. Don't let the lawyers rush you into making a quick decision." And sometimes you have to make quick decisions in bankruptcy because of the circumstances, but that was very sound advice, I felt like. And most of the time we as judges, we have that luxury. You want to rule as quickly as possible so the lawyers know what the situation is, but I found that good.
Having talked to a lot of judges over the time about judging, some people, I think, come to find out they weren't really cut out to be a judge. Some people find out they kind of seemed to be meant to be a judge. Where did you fall on that spectrum?
Well, I don't know that I was meant to be a judge, but I enjoyed being a judge. I enjoyed it, frankly, more than I enjoyed practicing the law. I guess being a solo practitioner, as I was good, but it was bad because you had to work and be in the office all the time because you were solely responsible for your practice. But I thoroughly enjoyed the years that I served as a United States bankruptcy judge.
Did you enjoy the intellectual aspects that came with it?
I did. Every time you grow in the job, you grow in any job, and I look back and it's kind of shaking my head at the way I was probably early on, and I'm sure perhaps others shake their head at the way I was when I walked out the door, but nonetheless, you do grow, and it is an intellectual challenge. Every time you think you've heard it all, you haven't heard it all, because there's a very bright lawyer out there who's going to raise issues that you never thought about. So it's mentally extremely challenging.
You always struck me as one who rose to that challenge in the sense you actually enjoyed it, as opposed to trying to run from it. If there was an intellectual issue or a hard legal matter, is that a fair assessment?
It is. I did enjoy it, and many folks think, well, you're in bankruptcy, so all you're dealing with are bankruptcy-related issues. But I had a trademark case, I had a patent case, contract cases, had some very interesting cases along the way that really get outside the realm of bankruptcy. Not a lot, but enough to enjoy.
Bankruptcy court at that time, had it become fairly autonomous?
It was indeed, yes. With the creation of or enactment of the 1984 Act, bankruptcy courts had their own clerks, bankruptcy judges had their own clerks. They were separated from the district court clerk's office. We were autonomous, independent still. All matters were referred under the law by the district judges, but they did that across the country. There's been no district court that I'm aware of that did not refer all bankruptcy cases to the bankruptcy judges. So yes, we were autonomous, had our own staffs, law clerks, bankruptcy court clerks, and
How did you like that aspect, the sort of standalone aspect?
Oh, I enjoyed it thoroughly. One of the early problems, if I want to call it a problem, was the bankruptcy court was situated in the First Tennessee Plaza over across the street. We were on the 15th floor in a commercial bank building.
What we used to call the Plaza Tower.
Plaza Tower. So we were isolated. I didn't have any other judges. Sometimes Judge Jordan or some of them would walk over and we'd have lunch together. But in 1998, after GSA purchased this building, the Howard H. Baker Jr. United States Courthouse, we moved over here and just really enjoyed the being on the fourth floor, the camaraderie with the other judges, and it was just a whole new experience.
Before we get to some of the other matters, a lot of people watching this may not have ever been a bankruptcy practitioner. In fact, I would guess the majority. What would a typical day in a bankruptcy judge's life look like?
Well, I'm an early riser, so I would get into the office 7 o'clock or perhaps a little earlier or a little later. I reviewed opinions the Sixth Circuit puts out daily, its opinions, and to the extent that they were bankruptcy related, I would review them, or to the extent they involved one of our district or magistrate judges' opinions, I would review them. I enjoyed that. And I would work on opinions, which I did during the entirety of the course of the day. If I had any I was working on. The way I set my docket up was I would have Chapter 13 cases every other Wednesday, and I would have Chapter 7, 11, and adversary proceedings every Thursday. The Chapter 13s were fairly substantial dockets. I could have 80, 100, 120 cases on any given Chapter 13 day, so I would take a day ahead to review all of those cases to make sure, even though many of them were routine, invariably something was going to jump out that was not routine, and I tried to be prepared so the lawyers would know that I was doing my job.
How many orders would you probably sign?
Well, this is going to be a little misleading, but I know in one order, my signature went out on probably 23,000 orders. Now, don't be misled by thinking that I reviewed all of those. Many of them are standardized orders in the bankruptcy system. They're discharge orders. They're just kind of routine orders. And when electronic case filing came into effect in 2005, that became a much easier process. But I can remember coming in a morning or after a long weekend or vacation and finding 100 paper files on my desk that I had to go through and sign orders. So there are a lot of orders in bankruptcy court, but many of them are routine automated orders.
Bankruptcy court is an incredibly high volume court, isn't it?
It is.
Parties, orders, rulings, all of that. I would take it.
It is, but again, many of them are just resolved administratively. Many of the Chapter 7 cases are what we refer to as no asset cases. There's just nothing there. By that I mean there's nothing for the benefit of creditors. The whole purpose of bankruptcy is for debtors is to obtain a discharge. For creditors is to maximize the return if there is any. The Chapter 7 cases involving individual bankruptcies, 96% of them go through administratively. The cases that the bankruptcy judges get involved in are where there's litigation.
Okay. Now, in addition to the physical changes you've talked about, not only the judging changing, and then you becoming the judge, and then your location changing from the Plaza Tower over here, how about the law? Bankruptcy law from, say, the 70s into the mid-2000s. Was there much change in the law?
Bankruptcy has always been a moving target, and Congress has always been called upon by the banks, the credit card industry, those moneyed folks who are affected by individuals who file bankruptcy, who want to discharge debts, to change the law. And we talked about the 1978 Reform Act. That was a major change. The 1984 Bankruptcy Amendments and Federal Judgeship Act, a major change. In 1986, as I recall, Chapter 12 was added to the Bankruptcy Code, which was a Family Farmers Act. In the Midwest, there was trouble with the farmers. 93, I think it was 93, there was a response, congressional response to bankruptcy judge who overturned a substantial union contract. The union, that did not sit well, and the Supreme Court upheld that. So Congress took care of that with a law. You can still do it, but you have to jump through a considerable number of hoops to overturn a union contract. And then the major Reform Act was in 2005.
And what was the overarching change in policy in that?
Well, I would have to say that prior to 2005, the bankruptcy code was debtor oriented, which you would expect it to be.
Sure.
It was the Debtor Relief Act. Debtors were to obtain discharges. In 2005, it tilted a little bit more towards the creditor. Somehow, word was out there that individuals and businesses were abusing the bankruptcy process. I never believed it to be true then. I don't believe it to be true now. I don't think it's proven to be true. But anyway, that was the building block for the 2005 Act, which created a congressional desire for debtors to file Chapter 13 if they were able to file at all, and they had to jump through some hoops now in filing bankruptcy cases.
All right, let's talk about your service in this way too. When you were appointed in 1986, you served not only in the Eastern District of Tennessee, but in the Knoxville Division. Were there other bankruptcy judges in the district at that time?
When I came on board in 1986, Ralph Kelly in Chattanooga was the only other bankruptcy judge. Ralph and I handled everything for a little while. Now, Congress had created a new bankruptcy position in Chattanooga in 1987, and John Cook was appointed bankruptcy judge in September of 1987. So there were at that time 3 of us, and I'll go ahead and...
But that strikes me as odd that there were 2 in Chattanooga, only 1 in Knoxville, and how many in Greenville?
Well, there were none in Greenville.
None.
I traveled during those early years until 93. I traveled to Greenville and Johnson City and held court up there one or 2 days a month. So I handled that Upper East Tennessee docket.
All right. And so who would be the next bankruptcy judge to join
Well,
the court?
in 1993, a bankruptcy judgeship was created for Upper East Tennessee. And Marcia Parsons was appointed to that position. There's a little bit of a story behind that, and I won't go into all of it, but statistically, Upper East Tennessee, the Northeastern Division, would not support a bankruptcy judge. You had to file with the administrative office all these statistics, and then they had to support it. Well, Judge Tom Hull was the chief district judge at the time, and very much wanted a bankruptcy judge presence, a permanent presence up there. So he and Ralph Kelly and Jimmy Quillen, who was the congressman at the time, got together, and because these statistics would not support it, they were able to get it through Congress on Quillen's recommendation through the Judiciary Committee. So that court was established, and as I said, Judge Parsons, who is now the chief bankruptcy judge, was appointed in 1993 and continues to serve. Then there was, when Judge Kelly retired, Shelley Rucker was appointed. Judge Kelly was on recall for a while.
What about Stinnett?
Judge Stinnett, that is correct. I'm sorry, Tom Stinnett was appointed first, and then Tom retired, and Shelley Rucker took Tom's position. Thank you.
And Shelley's still there.
Shelley's still there.
Marcia Parsons.
Parsons is there, and Judge John Cook is retired, and Nick Wittenberg is new bankruptcy judge. I don't know if he's been in office a year or not, probably a little bit less than a year.
And we'll go ahead just for a moment, and then we'll go back. You retired.
I retired, and Suzanne Balknight was appointed in March, I believe, of last year. No, November of last year.
Looking back again over your career, starting in the mid-'80s when you were appointed and throughout the 2000s, how did the workload change?
Well, it increased dramatically. When I came on, there was not that much. I can't give you statistics. It peaked in 2005. I've already referred to the Bankruptcy Abuse Prevention Consumer Protection Act, which went into effect, and the lawyers were concerned. So, again, we got 22,000 cases filed in this district. Since then, it has gone down, and before we started talking, interestingly, I received an email from the administrative office stating that during calendar year 2015, bankruptcy filings decreased to slightly over 844,000 across the country, and that's the 5th year in a row I believe they've decreased. They decreased to their lowest level since 2007. Now, they were low in 2007 because after 2005, there were 1.5 million cases filed that year across the country.
1.5 million. 1.5
million
in
or
1
thereabouts, yes. And there weren't anybody left to file after that. They had to recycle, I guess.
And so now it's about half of that.
Yes, just about a little over half of that. It's quite interesting.
During that time period, particularly the 90s and the 2000s, how did Tennessee rank per capita in the country with regard to bankruptcy filings?
Invariably, Tennessee is ranked number 1 per 1,000 households. Tennessee, Alabama, and Georgia. I think maybe Utah or Nevada, one of those states took it over for 1 year, small population states. But for some reason, Tennessee is always ranked at the number 1 spot.
Wow. You attribute that to anything?
I don't know. We're asked that. We're asked why so many chapter districts have more 13s than 7, why some have more 7s than 13. It's an unanswerable question. I know that mortgage foreclosures in Tennessee are easily done. You don't have judicial foreclosure. People want to save their homes. To what extent it's socioeconomically related, I just don't have an answer for that.
When you started, what kind of a staff or support staff did you have then, and how did that change over your career?
Well, the support staff has remained the same. Under the 1984 Act, bankruptcy judges were allowed to have a law clerk and a judicial assistant, and I always had a judicial assistant and a law clerk, so that's never changed. When we moved over here, due to the location, the clerk's office is on the 3rd floor, and that doesn't sound very far away, but it is in this building. So I did bring some clerk staff up here with me, but I had the same folks with me for many, many years, and they were invaluable.
You had a long-term judicial assistant.
I did. Shirley Vaught came with me out of the U.S. Attorney's Office when I came in 1986. She was with me for 23 years. And then Marilyn Dunn, who was my long-term court reporter, took over as a judicial assistant.
And whereas some of us rotate law clerks, you did that early on, but then toward the end you went with the more permanent law clerk situation.
I did. I had temporary law clerks for many years, and then 13 or 14 years ago, Shauna Veach came to work for me, and Shauna was such an outstanding law clerk, very, very knowledgeable about the law and very interested in bankruptcy law, and I couldn't let Shauna go. So she stayed with me, and she's with Judge Balknight. Now stayed with her.
Sure, she, like my law clerks, are invaluable.
There's not any question about that. But with temporary clerks, I believe the magistrate judges have a permanent clerk and then have temporary clerks also.
Right.
But most of them were out of law school, and by the time you get trained, it's time for them to move on, and that's kind of difficult doing that every year or two. So I found it well to have a permanent clerk.
As you look back over your career, first off, we talked about the volume. Approximately how many cases do you suspect you've handled in your 28 years?
Well, now, not bankruptcy cases. Cases involving litigation and hearings, thousands. I mean, many thousands of cases have gone through the bankruptcy court here in Knoxville over the years, but As I stated, many of them go through, this Chapter 7s go through administratively. Chapter 13s probably have hearings in most all of those cases because there's usually some controversy. Chapter 11 cases had hearings in all of those cases. But I've had many, in adversary proceedings, trials, many thousands of hearings over the years.
Are there certain ones, sometimes I know in that many it can get lost, but are there certain memorable cases or cases that stick out in your career?
Well, I remember the successes. Chapter 11 is very difficult. There are not many successes, but the one I do remember involved Watson's Department Store here in Knoxville. Morris Quinn, Representative Morrison's, did a very outstanding job. Morrison's had too many stores across the state. They needed to get rid of some, and they filed a Chapter 11. Got rid of some leases, reorganized, and went back in business. It was a very successful case. Unfortunately, the principal behind the business died a few years later, and Watson's was unable to go forward without that particular individual. We had a large case involving, I don't know that I even want to mention the name anymore, a Ponzi scheme. A broker around here, or a reputed broker, was selling non-existent stocks, and that case ended up brought $30 plus million into the trustee, who ultimately had to give it back because it was determined by the Court of Appeals that it was an estate issue, a probate issue, and probate matters do not come to bankruptcy court. So, but it was very, very interesting.
There's a lot of law
to say the least.
In that case.
Yes, it was most interesting. But every case you don't look at it, and you do the same thing in your court. You look at it from the individuals, and to the individual, it's a big case. They're looking for relief, whatever that relief might be. So I tried to treat every case the same. Some of them are high profile, you can't avoid that, but they're not any bigger than the case that the man on the street has.
You and I have talked about that what's memorable or high profile to persons reading about our cases in the paper.
Right.
For us, it's just one more case. It's just the person sitting out there happens to have a little more notoriety.
That's correct, and
people don't realize that about judges, do they?
No, they do not, and they're entitled to equal justice before the law, just like the big guy, the high profile guy is. No question.
Best memories being a judge for 28 years.
Well, my best memories are of people like you. The guys I was able to associate with, my staff. I had a wonderful staff. They were with me 15, 20 years or more, all of them. We got along well, and they did a lot for me. We have a court, the Eastern District of Tennessee, where the judges are very compatible. That's not true everywhere. But when I moved over here, Bob Muring was here, then you came along, Bruce Guyton came along, Judge Varlin, Judge Jarvis was here, Judge Reeves is now here, and I'm going to be in trouble for leaving people out, which I don't mean to do. My good friend Leon Jordan, I met Judge Jordan up in Upper East Tennessee when he was a chancellor, and they're good friends as well as colleagues.
I think people may not realize the camaraderie we have, like for lunch.
We do. We have resolved a lot of the world's problems, if only they would listen to us.
You and I and some others would eat lunch most every day
we
together.
We did indeed. And that was the most enjoyable time for me, because we are in an isolated job. You can't associate with the lawyers too much. In bankruptcy, there's a lot of fees awarded, and they're contentious sometimes. So you have to be very, very careful, and it's an isolating job.
Sometimes judges are referred to as occupying an ivory tower. You've just mentioned that it is an isolating job. How'd you deal with that?
Well, I'm a rather introverted fella, so it didn't bother me. I had my staff to talk to, my law clerks and you, other judges, so it wasn't bothersome to me.
Well, any comments you would have about qualities of a good judge or your own judicial philosophy or anything judging as opposed to bankruptcy judging, just judging in general?
No, I think to uphold our oath of office, treat everybody equally, rich or poor, and a lot of poor folks come through the bankruptcy court. Just treat everybody equally and fairly. And I found, and I believe it to be true, that at the end of the day, if a lawyer or litigant feels like you've heard their case, even if you rule against them, they can walk out of the court with their heads held high because they got a fair trial. And that's the main thing. I tried to research the law, be familiar with the cases that I tried, and reach a right conclusion. Sometimes I'd get reversed on appeal, but that wasn't because I was wrong. That was only because there was no other authority above the appellate court.
You retired recently. What led to that decision?
Well, I had 28 years. I was 73 years old at the time. I had served 8 years beyond retirement age. The Greenville position, when it was created, was a temporary position, which meant at the expiration of 5 years, unless it was extended, which it was a couple times, we would lose the position if a judge died, retired, or resigned. That position will terminate again in May of 2017, I believe. So whether it will be extended or not is problematic. It may not be. And I needed to pave way for somebody else to come in here so we'd have long-term position in case we do lose that position. So there were just a number of things, and it was time. I'd been on the bench 28 years. It was time for some new blood, new ideas, and Judge Balknight's doing a great job, and it is refreshing.
Is there anything that you wish I'd ask you about that you would like to talk about?
I don't think so. We've covered a lot of ground here in about an hour, I believe, and I appreciate the questions you've asked.
Last question, Richard. How would you like to be remembered from your time as a bankruptcy judge?
I would just like to be remembered as somebody who worked hard, who was fair, and who did their very best to reach the right decision. I did work hard, and I tried to come up with the right result. The trouble with the law is it's not all black and white, and a lot of it's common sense. And I think I've always felt like one before becoming a judge needed to practice for a number of years so they would have dealt with people. There are a lot of judges who did not practice, came into judiciary who are wonderful men and women. So I've been proven wrong about that particular theory. But would just sum it up by saying how much I enjoyed my time on the bench, my association with other judges, with the bar. It was a good ride.
I'm not sure interviewers are supposed to comment, but I think I can salve your soul that you will be remembered as one of an extremely great work ethic, always prepared, your fairness, you were above reproach. And for those of us who have known you, you're a better man than you were a great judge. So let me thank you first for your participation in the project, but let me thank you on behalf of the bar for your service to this legal community. So
thank you so much.